Hello, I'm AFP Roving Editor Mark Anderson, back with another AFP video. Check out our Rumble videos posted at AmericanFreePress.net. And I'm reporting today on a spate of favorable Supreme Court rulings showing that our republic has some resilience indeed. And that has to do, of course, with the big Titanic one, the overturning of Roe v. Wade, as well as the Casey decision. Let's not forget that. And then there's also matters pertaining to voter ID in North Carolina, school prayer-based issues, and Miranda Rights, and some other matters that I'll list here and go over. Of course, I'll put the most emphasis where it belongs, on the overturning of Roe v. Wade. And that happened June 24 by a 5-4 decision. And the court basically found, among other things, that when Roe came down in January of '73, it was based on constructing something new out of whole cloth. It had all the makings of legislating by the High Court, which is forbidden in the separation of powers in our constitutional republic. That alone, in a sense, doomed Roe. But as I've noted here, the abortion industry ultimately, was the victim of its own excesses, partial birth abortion and things like that. Thus, the pendulum inevitably swung the other way. In the 1992 Casey decision, which was also overturned with the same stroke as Roe, that took away the first trimester limit that Roe had. And without that first trimester limit on when abortions could be legally performed, you might say all the last restraints were taken off. And now that Roe v. Wade has been overturned along with Casey, that allows abortion laws to be determined by the states in a more or less pre-Roe fashion. We're almost going back to the legal landscape before Roe v. Wade. And indeed, this is really the most democratic way to handle the issue. Through their state legislatures, the people will have much more influence on what kind of abortion laws they support in their respective states. Women with unwanted pregnancies simply will have to go to those states that provide abortions. As it now stands, since Roe in 1973 basically invalidated state laws that prohibited abortion, now with Roe overturned, the states can awaken from their slumber, so to speak, and assume a more active role in terms of a nationwide context, in the collective sense. Thus, with Roe v. Wade now overturned, there are 22 states that are set to ban or severely restrict abortions. Many of them already do. These states either proactively passed laws in recent years against abortion in anticipation of Roe being overturned, and these are the trigger laws that have been set to kick in when it's overturned, or other states are simply dusting off older abortion restrictions that they've had on the books, some of them since before 1973. And that does leave 28 states, 28, which will likely run the gamut from more liberal to middle of the road, allowing abortion. So abortion has not been altogether outlawed. Let's keep that straight. Some pregnant women will have to seek abortions in other states, as I mentioned, but this is misleadingly cast purely as a hardship in the mass media. Another angle that's never really reported is that pregnant women who have to travel further if they do want to get an abortion will have more time to think about what choice to make. And if that means getting an ultrasound, for example, to see what a baby looks like in formation, that could help counteract the constant pressure that the tax-fed abortion industry exerts on young girls to get an abortion in a hurry and wring profits out of them before they have time to reflect and obtain more complete and more objective information. In other words, informed decisions, fully informed decisions. And besides, Justice Alito, writing for the majority, noted earlier this year, and that's in the leaked opinion that came out where we began to anticipate Roe being overturned, that Roe simply was structured too much like legislation, as I noted, and that made it internally weak, so it had hardly a leg to stand on, and it had to be artificially propped up by the media and medical propagandists via the use of nebulous language to cover up the grisly abortion procedure itself. Indeed, the word abortion itself only means to cease or to stop something. What we call abortion might be more accurately called termination. And some quick ironies and facts, and I'll get to some other matters in the Supreme Court realm. A 1973 prediction that there would only be one abortion for every 2 births did not pan out. In 2017, in New York State, for example, that state aborted or killed 105,380 babies. That's the state of New York. That same year, New York had 117,013 births, which means that things got very close to 1 abortion for every 1 birth, not 1 abortion for every 2 births, as was predicted in 1973. Very interesting. And the Washington Post just noted that the High Court's ruling will negatively impact women of color, totally ignoring the National Review's report that in New York City, black abortions often outweigh black births. Not to mention that Planned Parenthood founder Margaret Sanger intentionally sought to put the nation's first abortion clinics in black neighborhoods to cut the black population. So women of color, including babies who will grow up to be women, including women of color, arguably are much better off with Roe overturned. The bigger picture, some 62,502,904 reported surgical abortions have taken place since Roe was enacted. That's 1.3 million a year, just over 3,500 a day, 149 per hour, and 2.48 abortions per minute since 73. Worldwide, the Worldometer's website says abortions this year alone so far are totaling right around 21 million. And that's just so far this year, 21 million. Now, some of the other Supreme Court decisions of interest, of course, are Miranda Rights. The Supreme Court ruled right around the time of the Roe v. Wade ruling that suspects may not sue officers who fail to inform them of their right to remain silent for damages. And it means that the failure to administer the warning, a Miranda warning, will not expose a law enforcement officer to potential damages in a civil lawsuit. It will not affect, however, the exclusion of such evidence at criminal trial. In terms of the Second Amendment, the Supreme Court struck down a New York law enacted more than a century ago that placed restrictions on carrying a concealed handgun outside the home. Justice Clarence Thomas, in this case, wrote in his 6-3 majority opinion that the Constitution protects the right to carry a gun outside the home. The opinion changes the framework that lower courts will use going forward as they analyze other gun restrictions. And that's important because that has to do with weapons bans in California or a gun safety bill that President Joe Biden reportedly signed into law just this past Saturday. And it's June 27 as I speak, so that's just a couple of days ago. We also have voter ID. The Supreme Court said very recently, last Thursday in fact, that 2 Republican leaders of the North Carolina legislature could step in to defend the state's voter ID law, even though the state's Attorney General, a Democrat, is already doing so. But this opinion makes it easier for other state government officials to intervene in some instances in lawsuits when the state government is divided. And that can't help but strengthen voter protections in terms of making elections more secure and more honest, because we need more leeway for voters to prove who they are, to prove they're eligible voters, to prove they're voting in the right precinct, along with vote count improvements like cutting back or getting rid of electronic vote counting machines and other things like that. Accuracy, above all, is what we need in our elections. And even the firing squad. The Supreme Court ruled in favor of a death row inmate in Georgia who's challenging the state's lethal injection protocol and seeks to die by firing squad, a method not currently authorized in the state of Georgia. The court said the inmate could bring the challenge under a federal civil rights law that allows individuals to seek remedies when their constitutional rights are violated. The decision could make it easier for inmates to challenge their potential execution method. That's one that didn't get a lot of press. And last but not least, the Supreme Court's conservatives ruled in favor of a high school football coach who was reprimanded for leading post-game prayers on the football field's 50-yard line. And this 6-3 decision marked a victory for Coach Joseph Kennedy in his dispute with the Seattle area school district that placed him on paid leave for violating a policy that bars staff from encouraging students to engage in prayer. Justice Neil Gorsuch wrote for the majority, Respect for religious expressions is indispensable to life in a free and diverse republic, whether those expressions take place in a sanctuary or on a field, and whether they manifest through the spoken word or a bowed head. He added, the only meaningful justification the government offered for its reprisal rested on a mistaken view that it had a duty to ferret out and suppress religious observances, even as it allows comparable secular speech. So those are the really interesting and some very weighty issues of the Supreme Court in recent times, with the overturner Roe v. Wade and Casey leading the pack. So reporting and providing a little analysis for American Free Press, I'm the roving editor for AFP, Mark Anderson. We'll see you next time here on our website among our many Rumble videos.